presume introductions are not necessary, but I'll make them anyway. I'm David Lloyd. To my right is Bill Rimmer. We're both barristers. Everyone knows this anyway, I assume. So welcome. We're here tonight to talk about the Sale of Land Amendment Act 2019. This legislation was passed and received royal assent early in June of this year, and it makes fairly significant changes to the Sale of Land Act, certainly the most significant ones in the last 5 years. It covers quite a bit of ground, so four areas to be more specific. Firstly, there's a change in nomenclature, so what has been known as a prescribed contract ever since the Sale of Land Act was first enacted in 1962. That's all changed now to off-the-plan contracts, which is what they've been colloquially known as for a long time now. Secondly, and so various sections, pardon me, from 9AA onwards are amended to use the term off-the-plan contract. Secondly, there are some terms contracts, those relating to residential land, though, only, to be outlawed up to a certain, it's terms contracts involving a sale price of up to a certain prescribed amount. I'm not sure if what that prescribed amount is or is going to be. I think I heard somewhere about $500,000. Have you heard that, Bill?
No,
yeah.
I've heard that some talking about.
Yeah, $500,000 or something like that. Yeah, so maybe $500,000. We'll see anyway, because that provision, rather those provisions, aren't in effect just yet. Likewise, there are new provisions which prohibit altogether the Henry Kay style of rent-to-buy schemes and land banking schemes, the Belarus-born Henry Kay, as he's known. And again, that's not operative as yet, but it's in the legislation. And last but by no means least, sunset clauses in off-the-plan contracts. In residential off-the-plan contracts, I should say, are now, as of June, regulated in terms of a vendor's ability to act on them. And that's the focus of today's seminar. Now, I'll just mention a couple of things briefly. One other notable feature of the legislation is the fact that it has staggered commencement dates. You have, for instance, some provisions, and most of the ones relating to sunset clauses, bar one, but most of them apply from 23 August last year, which was when the government announced that it was going to do something about vendors acting under sunset clauses, and then everyone lost interest because of the election, and finally we now have this amending act passed. So some provisions operate from early June this year, and some, the ones relating to terms contracts, rent-to-buy schemes and land broking schemes, are not yet in effect, but they will come into effect on the 1st of March next year. So I'll hand you over. As I say, the focus of today is sunset clauses and how this amending legislation deals with them. And my learned friend will regale you with all of that in just a moment. He'll focus on new sections 10A to 10D, and I gather I'll be allowed to return for about 10 minutes towards the end, to talk about section 10E. But just before I do that, one announcement. I presume everyone that's here today has some interest in property law. Well, there's a major imminent event, which is the release on Friday, I am told, of a brand new contract to sale of land, which is no longer real estate, it's land instead. That's co-badged by the LIV and the REIV, and that should be hitting the shelves in the next few days, probably Friday morning, I'm told. There will be a seminar, another Greens List seminar on that contract, at which we will, both Bill and I will be present, and I can tell you all the ins and outs of this new contract. It's completely rewritten. You won't recognise it. The authors believe that it's bigger, better, faster, stronger, and but that'll be in October. So I'll hand you over to Bill.
Thanks, David. Welcome, everyone. We are, as David said, here to talk tonight about the Sale of Land Amendment Act, which, after a long and much bruited introduction over the last 12 months, has finally become law, having received royal assent on the 4th of June this year. So, as David mentioned, it does three major things. There are a lot of minor things. For example, we can't have auctions on Anzac Day anymore, if anyone ever did, in the mornings. But apart from that kind of detail, it regulates the exercise by a vendor of land under a sunset clause in a residential off-the-plan contract if the plan of subdivision has not been registered or an occupancy permit has not been issued by the date specified as the sunset date in the contract or any extension of that date. The main provisions of this part of the bill are backdated to the 23rd of August 2018, which is the date on which the earlier version of the bill was introduced into the Legislative Assembly before the election last year. So that's one thing that it does, and as David says, the retrospective effect is now in place. So from the 23rd of August last year, any rescission notice or the termination notice issued under a sunset clause is invalid unless it had the consent of the purchaser. So the second part of the main thing that the Act does is to prohibit rent-to-buy contracts for residential land. That is what you think residential land is, except for residential land that's also agricultural land. So it doesn't cover the homestead, the farmhouse on the farm. So that gives a purchaser under a terms contract for the sale of a residential property a right to avoid the contract and obtain a refund of the deposit and any money paid under the contract. And as David says, there will be an upper limit on what constitutes a terminable residential terms contract. But those provisions don't come into operation until the 1st of March 2020. So I'm not considering those further tonight, and I don't believe David is either. The third thing is to introduce us to a new term called land banking scheme, and it defines what that is, and then it regulates those. So these schemes are schemes which give options to purchasers to buy land under an arrangement that essentially means that the purchaser is paying money under the option agreement to secure an interest in or a right to buy the land at some time in the future, and their money is then used in the development, and of course the development then goes sour and we're back in the very place that we were not meant to be in under off-the-plan contracts. So again, those provisions, as David says there, we're calling them the Henry Kay provisions because they are designed for those kinds of schemes that Henry Kay is spruiking, one version of them. So they come into operation on the 1st of March. So they're not of concern tonight either. You'll get two opportunities to hear us because this is foreshadowing that we'll probably have another seminar next year.
I'd say March next year on the card.
Yes. Another introductory comment to make is that as consumer protection legislation, those provisions will almost certainly be interpreted strictly against the vendor so as to ensure that purchasers have the benefit of the intended protective effect of the legislation. So tonight I'm considering the new sections 10A to 10D, and David will be considering 10E. So when it comes to sunset provisions, there's long been controversy in the profession about whether vendors under off-the-plan contracts should have an unfettered right to terminate if a particular agreed sunset date is not reached. The The problem with, and the suspicion always has been when vendors exercise this right, that they're not doing it in good faith and that they are in fact attempting to either forgive themselves for inefficient and deleterious prosecution of the development, or worse still, in a rising market such as we've just been through, that the vendors are trying to claw back the value, the added value that has accrued since the date on which the contract was signed. And we've all heard of egregious examples of this, where vendors go to purchase and say, well, I'm going to miss the sunset date, so I could terminate, but what about you re-enter into a new contract with me for $80,000 more? And purchasers have been rightly aggrieved. Now, it's true that purchasers has a right to hold the vendor to account if the vendor has breached express or implied obligations to use reasonable endeavours, and that has always been the response, and that is the current law. A vendor can't take advantage of its own breach of the contract to terminate under a sunset clause. But the problems that approach raises for purchasers are really obvious, because it's the purchaser who then bears the onus of establishing on the evidence that the vendor has not used reasonable endeavours and thus that its termination is invalid, so that the contract remains specifically enforceable notwithstanding the vendor's purported termination. The purchaser doesn't have access to the developer's files, and so it's not able to ascertain what the evidence is, to see whether there's a proper basis to commence such a proceeding. Once commenced, the litigation risks are high, and the costs of discovery and running a trial are, for many purchasers who are, after all, when we talk about residential off the plan contracts, they're generally, a genuine consumer. So even a strong case with a reasonable prospect of recovering costs on a standard basis at the end has to be funded by a purchaser until judgment, and the differential between standard and solicitor client costs has to be borne alone by the purchaser. So all these are things which basically meant most purchasers said, look, I'm tremendously aggrieved, but I just can't face the prospect of running that litigation. And so the vendors relied on that, and I'm talking only about a few developers here, not everyone, but the purchasers were prejudiced. So the regulation has completely reversed all of that and placed all of the onus just about onto the vendor. First thing to note is there's this new term that's been introduced that David mentioned as well, a residential off-the-plan contract. So residential off-the-plan contract means an off-the-plan contract, and that's a new definition in itself in the Act, but as David says, we've all been using it, where the lot's proposed to be used for residential purposes. The restrictions on the exercise of a termination right under a sunset clause has no application to land sold under an off-the-plan contract for commercial, industrial or agricultural purposes. But one interesting thing to note at the start, I don't know whether this will become the subject of litigation or whether this will resolve itself in a common sense way, but the definition of residential off-the-plan contract doesn't specify who must be proposing to use the land that's being purchased, the lot, for residential purposes. In most cases, that's not really an issue. An apartment in a multi-unit development is generally sold by the developer direct to the purchaser. But what if the purchaser might be an interim, a middle developer? So this often happens where you've got the land developer and then a builder developer buys the lots in order to actually build the residence on the land and then sell it off to the ultimate residential purchaser. Arguably, the builder developer is not proposing to use the lot for residential purposes, but rather for commercial purpose of further development and on sale for profit. So does that mean the off-the-plan contract to which the builder-developer is party as purchaser is not a residential off-the-plan contract within the meaning of the Act? Now, I'm suggesting here that the ambiguity would be resolved in the builder-developer's favour, the purchaser's favour, because you really apply the principle here that the legislation is consumer protection, and therefore it should be interpreted in favour of the purchaser where there's ambiguity, consistent with the usual principles of construction, of course. So the purchaser may not itself be proposing to use the lot immediately after settlement for residential purposes, but it nonetheless proposes that use by buying it in order to further develop it as a residential lot. A broad approach to the construction of consumer protection legislation was said to be preferred to a narrow one in relation to the onerous restrictions and recovery of commission under the Estate Agents Act 1980. I'm suggesting the same approach would be applied in relation to the construction of residential off-the-plan contracts. So just because someone's buying it in order to, as a sort of, in the old days I think we might have called them spec builders or whatever, even though they've got a commercial intent for the lot in the interim, ultimately the purpose which they're buying it is to build a residence and to sell it to somebody. So the intention is that the lot that's being purchased will be used for residential purposes.
Eventually. Yeah.
Eventually. Anyhow, we shall see whether someone takes that point. Now, I've already mentioned that the existing law gives a purchaser who's a victim of this kind of conduct by a vendor, the bad faith conduct of terminating under a sunset clause for an improper purpose, that's already prohibited under the general law. The Court of Appeal held in Joseph Street and Tan, this is all well known to you of course, that an obligation to use best endeavours to have a plan registered in time requires the vendor conscientiously to apply itself to the task of securing approval with the vigour to be expected of it if it were prudently attempting to secure its own interests, and to continue to do so until it should reasonably judge in the circumstances that further efforts would have such remote prospects of success as to be likely to be wasted. That's the statement of the Court of Appeal. What the vendor can't do is take advantage of its own ineffective or inefficient measures to comply with its contractual obligations so as to deprive the purchaser of a substantial chance that the condition would have been fulfilled. So, what constitutes ineffective or inefficient measures has previously been something that the purchaser has had the onus of establishing to the court's satisfaction. And one, as I said, can readily see the difficult forensic task that purchasers face, not to mention the commercial disadvantage to a purchaser, the onerous burden of carrying the litigation as plaintiff through to its conclusion. Now, of course, the approach taken by the courts, even where the vendor's rescission was challenged at general law, has still required the vendors to come forward with some explanation, it's placed some onus on vendors to give an explanation and justify the steps that they've taken to progress the subdivision. So it hasn't been quite as 100% against purchasers as I've perhaps painted it, but nonetheless, in practical terms, it was very, very difficult for purchasers. So what now occurs is the procedure that's set out in sections 10A to 10E in the Act. 10A to 10D are already in well, they're all in force now, but 10A to 10D have retrospective effect from the 23rd of August last year. I've extracted those provisions in my paper, and I see David has put them on the front of his as well. And the main provision I'm focusing on will be 10B, which basically prohibits a vendor from rescinding a residential off-the-plan contract under a sunset clause, except as provided for in this legislation. And then subsection 2 goes on to provide the circumstances in which, therefore, the only circumstances in which a vendor may rescind a residential off-the-plan contract under a sunset clause. And that is if the relevant plan of subdivision has not been registered by the sunset date, or an occupancy permit has not been issued by the sunset date, and under subsection 3, that before rescinding the contract for one of those reasons, under a sunset clause, that the vendor has obtained the written consent of each purchaser to the rescission, after giving each purchaser at least 28 days before the termination, written notice which sets out the things that are specified in that section. So now the vendor has to go cap in hand and say, look, we all signed these contracts up 3 years ago or 18 months ago. I've used my best efforts to get this through and I'm stymied. This is the reason that I'm stymied, and this is what I've done along the way. There's been no delay, or if there has been delay, it's not been because of my inefficient and deleterious conduct. But I also have to tell you that you're not obliged to consent. So if you have given that notice and the purchaser has consented in writing, then you may rescind. If the purchaser doesn't consent, you have to go off to court, and David will talk about that in a few minutes. 10C is what we would expect to see in consumer protection legislation. You can't have any contrary provision in the contract, and if there is one, it's of no effect. 10D, I will make some mention of in a minute, that specifies that if a vendor terminates or purports to terminate a residential off-the-plan contract in contravention of the division, then that is taken to be a breach of the contract. So that gives rise to remedies in favour of the purchaser for breaching the contract. So leaving 10E to one side, springing over it for the moment, I will just point you to 10F. 10F is an additional disclosure requirement that's to go into contracts, or it's actually to go into the sunset clause itself. That's something that solicitors will need to be aware of. It's required to go into contracts from the 1st of March next year, but the long lead-in time is obviously to give people who are using standard forms plenty of time to change the forms, to run out their forms if that's still relevant with in this electronic age. Also to give people time to be informed, and also if agents have got contracts out there that don't have this disclosure in it, it gives time for sales to be entered into without the disclosure in it, without there being a breach of the Act. So from the 1st of March next year, though, it's very important to include the disclosure in section 10F if you've got a sunset clause in a residential off-the-plan contract, And what's more, really, the good practice would be to start doing it now, because if an agent keeps your contract on file and then uses it accidentally after the 1st of March, then all hell could break loose, particularly if you didn't say to the agent that they shouldn't do that. Anyhow, best management of that risk is to actually comply from today on. So it's important to note that these provisions have retrospective effect, and that's the date, as I said, on which the earlier version of the Sale of Land Amendment Act was introduced, or the bill was introduced into the Legislative Assembly. That bill actually lapsed as a matter of law and procedure when the government dissolved Parliament for the general election, and everyone thought, or some people thought, aha, I've got you. Now we can just pretend it doesn't exist and it's gone away altogether. And but I think there was a reasonable expectation that it would be reintroduced by the new government. Certainly if the old government was re-elected, as happened, and I think a lot of people even expected that it would have been even if the government had changed. But it lapsed, but it was ultimately reintroduced into the new Parliament and passed and is now law. So the new section 10E, which authorises the vendor to obtain an order from the Supreme Court if the vendor doesn't consent, if the purchaser doesn't consent to a termination, that will apply to any residential off-the-plan contract that is or was on foot as at the 4th of June 2019 or later. The reason that doesn't have retrospective effect is because you can't apply, or at least the policy of the legislation is not to apply, that you can't apply to the court for forgiveness for not having complied before the 4th of June. All you can do is apply prospectively. But I think you might be going to go into that in some...
I'll try and avoid it, but...
All right. Well, the important thing there is that obviously, if you get to the 4th of June, you've had an invalid termination of the contract. Well, the contract's been on foot, and so it's still on foot on the 4th of June. If the plan was registered before the 4th of June, then your sunset clause is gone, and you've got to complete. But if the plan was still unregistered on the 4th of June, and you issued an invalid termination notice, well, the termination notice that you issued was still invalid, but you could issue a new one because the sunset clause is still in existence. And then you could, if the purchaser doesn't consent, go to the Supreme Court. But the Supreme Court's validation of your termination is prospective, it's not retrospective. So what this all means is that the termination is ineffective if it was done at any time after the 23rd of August last year, and the contract will be specifically enforceable unless each purchaser consents to the termination, provided that notice is given in accordance with the notice procedures that I referred to earlier. That also the vendor will have committed a breach retrospectively. I don't know how that works in terms of logic or in the minds of common lawyers, but retrospectively you've breached your contract, and thus presumably, and this is presumably the intent, that the vendor would be liable to pay damages to the purchaser in lieu of or in addition to specific performance. The vendor, however, will have the right to apply to the Supreme Court for an order permitting the vendor to rescind the contract now, and the court may make that order if it's satisfied that making the order is just and equitable in all the circumstances. And in making the order, the court has to have regard to the 6 matters in paragraph A to E of 10E3, which we'll learn about in a few minutes. I've raised a question here in my paper, which I'll largely leave you to read for yourselves. It's just an interesting theoretical question that occurs to me, is whether the effect of Section 10D might be that a vendor could retrospectively repudiate the contract, or be taken to have retrospectively to have repudiated the contract because it was a breach retrospectively to have issued a defective or an ineffective rescission notice. My view I've outlined there, but just to put it very briefly, is that it's not as simple as saying, okay, you've issued a termination notice and that was a breach of contract, and therefore, because the termination says you weren't going to go on with the contract, that's a repudiation. The law is more subtle than that. There is a tendency amongst some practitioners I know to find repudiation easily from facts that are presented to them by clients. That is really not the way that the law approaches it. I know Mr. Lloyd agrees with me on this. We don't agree on everything, believe it or not, but on this I know we're of one mind, that the kind of evidence you need to prove a repudiation is a complete and utter intention to regard yourself as discharged from the contract once and for all. And although a vendor may have issued a termination notice, once pointed out that, well, that's going to be ineffective when the new law comes into effect, and it surely will, the vendor would have been entitled to say, well, I'll wait and see. And the position I'm taking is that my notice is valid and it is under the existing state of the law, but I'm not going to do anything precipitately here or put it beyond my power to sell the property to you, to go on with the contract, if it turns out I'm wrong and my expectation is wrong, and you're right that the law will change, and that will have retrospective effect. What I'm saying here is just simply taking a vendor having taken a wait and see approach. If the vendor had taken a more high-handed approach and said, the law is the law as it currently is, and had returned the deposit to the purchaser, or gone off and tried to sell the property again to somebody else, that would be, of course, a different matter. That would be evincing an intention, potentially, to regard oneself as discharged from the contract, absolutely, or only to be willing to perform it in a manner inconsistent with the contract. So don't be too quick, this is my recommendation anyway, not to be too quick to find repudiation just because under Section 10D the ineffective termination notice that was served after the 23rd of August constitutes a breach of contract. However, Section 10D will give your client a right to damages if loss is suffered as a result of the ineffective termination. So, in obtaining a purchaser's consent to termination, the vendor has to give at least 28 days prior notice, setting out the three things in Section 10B3. One is the reason why the vendor is proposing to terminate. Maybe, for example, the council has said, we're never going to issue a planning permit for this particular development. And then perhaps the reason for delay in registration of the plan. Maybe the builder was insolvent and we've made every effort, but we couldn't appoint a new builder in time to meet the very tight 8-month sunset clause. And also to tell you openly that you've got under no obligation to consent, even though I'm asking you for the consent and even though I've given you the reasons why and explained my delay. So generally giving an explanation and the requirement to obtain consent will in most circumstances guarantee that the purchaser won't consent unless it's really a clear case where the contract has almost in effect been frustrated because of changes in circumstances since the day of sale. Now, one potential issue here is that Section 10B3 provides that before rescinding a residential off-the-plan contract under a sunset clause, the vendor must obtain the written consent of each purchaser to the rescission. Now, perhaps that might raise the question whether that means that if you've got a development with 20 purchasers of lots and you've sold 20 of them off the plan, that you have to get the consent of all 20 before you can terminate any one if you've reached a sunset date. I don't believe that that is the construction of that to be given to that clause. The reference to each purchaser has to refer back in the actual section itself to the contract that's being terminated. Just the wording of the section would seem to necessitate that construction. So that what it really says is if there's more than one purchaser, then each of those purchasers has to consent separately and individually to the termination. The consent of one of them, even if they're purporting to act as agent for the others, is not enough. Now, there is a definition of purchaser in Section 2 of the Act that says that the purchaser includes any person from time to time deriving an interest under a contract of sale from the original purchaser under the contract. Now, I did say there that that includes a nominee, but that's something actually which I would like to reserve a right to have some more thought about, because on one view a nominee derives an interest under a contract by deriving an interest in the purchaser's interest, but of course the nominee doesn't have a direct interest in and of its own right or derived from its own entitlement to specific performance of the contract, because the nominee is not entitled to specific performance of the contract. Anyhow, we can leave that to another day, but certainly each purchaser named in the contract has to give consent for a valid termination under a sunset clause by a vendor. Section 10B3 of the requirement to obtain a purchaser's consent obviously in the future will interact with Section 10E about obtaining the court's authorisation to rescind. So that there seems to be a page missing, but anyhow, I think it's in the printing. That's all right. The thing with Section 10, the difference between the New South Wales, in fact, almost the only difference between the New South Wales legislation and the Victorian legislation is that in New South Wales you can't go to the court unless you first tried to get the purchaser's consent and the purchaser has refused. Whereas in Victoria, the Section 10E stands in separately from and side by side with 10B3. So you could just go straight to the court. Although I think, as David will explain, there are potential consequences of doing that. So I think that's time to do the transition.
Okay, thanks, Bill. Now we move on to the last item of the evening, which is Section 10E. If you have my paper handy, you'll see the section itself is extracted there on the front page. So what this does, pardon me, it's something new, at least in Victoria, but there's been a very similar provision in operation in New South Wales for similar but not identical since November 2015. So there are some cases which provide guidance on how the Supreme Court in Victoria is likely to interpret it. Can everyone... Yeah, is that better? Okay. We'll move it a bit closer. So, whilst it is blue sky for Victoria, there is guidance from particularly two very substantial cases, judgments in cases in New South Wales. So what it does, in a snapshot, it allows a vendor to apply to the court, not a purchaser, but remember purchasers have avoidance rights under sunset clauses under section 9AE of the legislation. It's a vendor, so it's a vendor only. It's an off-the-plan contract, but it's a particular one, residential only. Bill's spoken about that. The application is made to the Supreme Court, not the County Court, not VCAT, not the Magistrates Court, nowhere but the Supreme Court. And it's an order that is what's sought, and it's an order permitting the vendor to rescind under the sunset clause. There's various definitions in section 2. There's a definition of residential. One curiosity is that it says a residential off-the-plan contract is an off-the-plan contract where the lot is proposed to be used for residential purposes. Now, Bill has said a few words about that. It doesn't say used for residential purposes when. That's one point to be noted, but may not mean immediate. So residential will take, I suggest, the ordinary meaning, and that connotes a place of residence, somewhere, a place where someone lives. But in, for instance, the Residential Tenancies Act, you've got a slightly more elaborate definition which qualifies with the use of the word primarily. Now, here the word primarily is missing, and it does raise the question of what happens if a purchaser is intending to primarily use the lot for residential purposes, but also for some ancillary use, maybe some sort of business or office. My suggestion is in this paper that that's probably good enough. There's the question of what rescind means and rescission, but that's of no great practical import, and I'm not going to address that today. So the Section 10E came into operation, as you've heard, on the 5th of June 2019, in contrast to the preceding Sections 10A to 10D. So 10E plainly applies to a contract that's entered into on or after the 5th of June, but reference to Section 54 towards the end of the legislation shows that there's an additional application, and that is to a residential off-the-plan contract which is in force, still in force immediately before 5 June. But there is a qualification except where there's a proceeding on foot, and proceeding would mean proceeding before a court, I suggest. That would be a proceeding brought by a purchaser, and there's, as you've heard from Bill, there's all sorts of difficulties with that, hence this legislation. So you could have a situation where a vendor has given a termination notice after 23 August, but with and the purchaser hasn't brought a proceeding on foot, which is on foot, and the purchaser has not, if the purchaser has not accepted the termination, the purchaser might have, and that's the end of everything. But if the purchaser hasn't, then the contract remains on foot because of the retrospective operation of the preceding 4 sections, 10A to 10D. So that if you've got a plan that's still unregistered, if it's registered, again, that's the end of the matter, but the vendor may then apply for an order under 10E now. How that's done, pardon me, the Supreme Court rules indicate how that's to be done. It's a provision where a statute allows for an application to be made to a court. You can use, and are supposed to use, in fact, an originating motion, and that's how it would be done here, in the form of the rules, and a summons to bring the matter before the court. who would be the defendant. There should be a defendant in the proceeding, and the defendant would be the purchaser or purchasers in the particular contract. Query whether it's appropriate for any nominees to be defendants, but I'm putting that to one side for the time being. Now you might have, this might be a plan of subdivision with multiple lots and multiple contracts. So the vendor may wish to bring a proceeding against all of those purchases, and as was done in the two New South Wales cases that I alluded to earlier. But if that is done, it certainly can be done, it seems, then the court will look at each contract separately, because when we come to the factors that the court looks at, one of the factors the court looks at is the position of the purchaser, and it may well be that different purchasers of different lots are in different positions. And that suggests that running a test case, if you like, in this scenario with just one purchaser as defendant probably won't work. It's going to be all of them, or each. You could have a separate proceeding in relation to each contract, or a multi-party proceeding. Now, it's no impediment to this application being brought that the consent of a purchaser has not been sought or obtained under Section 10B. Position in New South Wales is a little bit different, but that's the position here. However, there's a catch, because the end of Section 10E is subsection 5, and that deals with costs, and it makes the vendor liable for the purchaser's legal costs in the proceeding, and that would mean win, lose or draw, unless the vendor satisfies the court, so there's the burden of proof right there, that the purchaser unreasonably withheld consent. So for that reason, it can be expected that vendors will ordinarily seek consent as a first step, but they don't have to. Of course, if they do consent, there's no need to bother the court with an order allowing rescission, because you've got a consenting purchaser. What the court is entitled to do is make an order permitting rescission if the court is satisfied that to do so is just and equitable in all the circumstances. That's a meaning that's been considered, that's an expression that's been considered by the High Court in 2012. And in terms of arriving at that conclusion, there are several factors that the court must have regard to, and they're listed in subsection 3, and I'll come to them in just a moment. But compliance with the contract may also be relevant. Now, I won't go through, you can read all this in the paper. I'll simply make the point that in this regard, at this time, that Section 10E does not create, as was suggested in, I think, both of these New South Wales decisions, does not create an independent statutory right of rescission. In other words, or an entitlement to rescind via consent of the court. It operates by reason of the existence of the contractual entitlement on the part of the vendor to rescind under the sunset clause in the first place. But what 10E does obviously do, and this is most important, it relieves the purchaser from any obligation to demonstrate a failure on the part of the vendor to do what the vendor was supposed to do under the contract, because the vendor is bringing the Section 10E application and therefore bears the burden of proof of satisfying the court that it is just and equitable for orders to be made. Now, there are there are 7 factors. The court is directed to have regard to them, and the High Court has said what that means. Take it into account and give some weight to it. What weight is a matter for the court to determine, acting judicially. The first factor is terms of the contract, obviously the sunset clause itself, and the second one is unreasonableness. Unreasonableness or bad faith. Bad faith has been considered by the federal court in another context, but there's some guidance as to what that means. Unreasonable conduct may, there are some examples I've given in the paper, but certainly a vendor who's manipulated events or manufactured delays is almost certain to be found to have acted unreasonably or in bad faith. Reason for delay, that directs attention to the degree to which delay was attributable, can be brought home to the vendor as opposed to perhaps someone else, someone that the vendor doesn't have control over presumably, or circumstances that are totally beyond the vendor's control. The vendor is the one best placed to adduce evidence, and the court, I suggest, will expect the vendor to do so. Likely registration date, again, that's a matter for the vendor to put some evidence before the court about. Increase in value, expert evidence will need to be before the court to see if there has been an increase in value, and that then relates to the next factor, which is effect on purchaser. One obvious one obvious effect is the loss of benefit of the contract if the market has risen, as Bill mentioned, if it has risen as it has done over the last decade until a year or so ago. Other relevant factors, I've listed several of them. Nothing leaps to mind, although you've got the flip side of the market value going up, because that would be a windfall gain for the vendor, and that's a factor for the court to consider as well. Almost there. Powers of the court. So firstly, there's the main order, which permits the vendor to rescind. Section 10E sub 4 then allows the court to make any other order which it considers to be also just and equitable, and giving an example of reasonable compensation of the purchaser. Costs. 10E sub 5, as I've mentioned earlier, mandates that the vendor is liable to pay the purchaser's costs. So unless the vendor satisfies the court that the purchaser unreasonably withheld consent under Section 10B. In one of these cases in New South Wales, the vendor's application was rejected, and the court concluded from that the fact of rejection that the purchaser was not unreasonable in withholding consent. But I've suggested in the paper that doesn't mean you can flip the coin. Just because the vendor is successful does not answer the question of whether the purchaser acted unreasonably. That's a fact. That's a question of fact. In the Queensland decision, it's been said that depends on all the circumstances. That's a common formula. Reasons need not be given. There are some leasing cases dealing with refusal of consent to assignment of lease that give guidance as to some of the relevant factors there. So the absence of reasons allows a court to more readily imply that refusal was unreasonable. And the reason for the refusal must be something affecting the subject matter of the contract and not something extraneous or dissociated. And that's it for Section 10E. We may as well move to questions. We have 5 minutes or so. I'm delighted to answer your questions. Just before I go, we do have a question about whether this legislation regulates clauses that are sometimes encountered in larger, in off-the-plan contracts for large developments, where the vendor reserves the right to pull the plug if at any time the vendor determines that it is the project's not viable or not commercial. There's sort of wording along those lines.
There's lots of different versions of
lots of different versions.
Those kinds of clauses. If you're not able to obtain finance, or if the council imposes a condition that the vendor considers is
unpalatable,
onerous.
Yeah. More than unpalatable.
Well, these are genuine commercial terms, and the reason that they're drafted, they're not just put in for as ruses for avoiding the contract, but they obviously all suffer from the same problem, that they could be used for that purpose.
Yes, they're not. The short answer, apart from that, the short answer is that they're not. Such clauses are not regulated by this legislation, although, well, I suppose that is the short answer. In general terms, There was a suggestion, apparently, in the early days that that the legislation might have extended to them, but
Well, what I heard, it's all just gossip that you hear around the traps, of course, but that when the legislation lapsed and there was consideration of reintroducing it in the new term of Parliament, that there was consideration given, or there was some talk as to whether it should be extended to cover more clauses than just sunset clauses as defined very specifically in the legislation. And obviously that didn't proceed, but one reason for that may well be that in having to do that, they would have to refer the legislation right back for consultation, right through all the processes of legislation, which would have meant delaying the sunset provisions, which really are the mischief that everyone was trying to remedy as quickly as possible. I think what you say about the legislation is absolutely correct. As it's presently drafted, the definition of sunset clause is very specific, and it's limited to a right to terminate for two reasons only. One is failure to register a plan of subdivision by a particular date, or failure to obtain an occupancy permit by a particular date.
now we can ask.
Yes.
Oh, there's a microphone about a roving microphone. So
and indeed, there's got a monitor to determine the priority.
yes.
My question is actually in relation to the rent-to-buy prohibition, and I know you're not here to talk about that, but I wanted to specifically ask that because, just to clarify, so is it an absolute prohibition on terms contracts? And I'll give you a scenario. One of my clients, who is a developer, number of purchasers weren't able to settle the contracts, but what they then agreed to do was to enter into a terms contract. So there was a subsequent contract drafted, and these terms contracts now are on foot. So is the proposed changes from 1st of March 2020, would they completely prohibit that scenario?
Well, I won't retrospectively invalidate the solution adopted in your particular case, or the case you're referring to, but they would prohibit them. But as David says, there's going to be a threshold for the definition or for what constitutes a residential terms contract, so it's 400,000, isn't it?
That's interesting.
Oh, we've got an authoritative source, none other than Russell Clocks. Please stand up. Well known to us all. So it's 400 apparently, yes.
Not much, is it?
No, so... But then again, these types of rent-to-buy schemes, sometimes called wrap finance, they all tend to be for people who really are unable to buy property obtaining usual finance. So they're not purchases of substance. I don't think has that answered your question?
I might just say rent-to-buys. It looks to me like they're out completely, and
Yes.
that was my understanding. And also, I think
Well, that's right. Answering your question, it applies to all terms contracts subject to the threshold for residential terms contractors.
but it's the prohibition is on selling, so that would mean selling after 1 March. That's all for next year.
Bill, just following on your comment before, I've got two questions, and I'll give you the second one is a real live recent example of the circumvention of the new Act. The first one is on 10B3. Was your view there that in the example given of 20 purchases, vendor writes to the 20 purchases and 10 say, yes, I'm happy to exit, consents, and the other 10 say no? Are you saying that the 10 that consent can't, they're not terminated, those contracts? And
No, I'm saying they would be terminated if they're 10 separate contracts. And indeed, the New South Wales cases, as David says that even in terms of the court's validation of a termination, they're all contract by contract.
Each contract by contract, that's right.
So the 10 purchasers who consented, their terminations would be valid. The 10 that didn't consent, the vendor, they're not terminated.
But if there were 10 purchases under one contract, or if there were 20 purchases, I know that's a ridiculous number, but if there were one contract with 20 purchases, then you need all 20 to consent.
Yeah, that's right.
It's a rather...
All right. The recent situation I had, and I think it works, what the developer did was our sunset expiry was coming up very soon, so they basically gave us the clause where we're not going to get it registered, we haven't started, blah, blah, blah. They actually tried to do it a while ago, and they were wanting to deduct some money from the deposit money. So we said to them, go jump. They've then, post-June, come back and tried to circumvent it, knowing that their sunset clause hasn't expired. It's going to expire soon, and I believe they've done it correctly in the sense of they've come back and said, look, similar to the point you were saying there, that, look, we can't complete it, blah, blah, blah. We're happy now to give you the full deposit back plus interest on deposit. So I think that works. It doesn't fall under this provision.
Anything can be done by agreement. If,
Well, you mean, is the purchaser's consent now being sought?
Correct, but it hasn't been done in the proper form, but I still think it works, that there is...
Well,
it wouldn't be consent
it's
for the
not
purpose of the
consent
Act,
for
no.
the purposes of the Act, but this does raise a rather interesting question, is what if purchasers have consented anyway, in the sense that they've just agreed to terminate the contract, as Russell says, you can do anything by agreement. Or was it David?
Well, yes,
David that said
anything by agreement.
But I'm sure Russell would say it if you've been asked. But I'm going to say that's still a grey area, because yes. Russell? Was that the end of the question? Yeah.
Well, just on that point, I'm concerned that the legislation revitalises a dead contract. A contract which was terminated after the 23rd of August last year and before the 4th of June this year is apparently, by the legislation, revitalised.
Yes.
And that, what does that do to the purchaser who did consent? We've now got a contract going again.
Well, I think that's a very good point, especially if there was a repayment of the deposit and the purchaser agreed to that.
But could it not be that the legislation applies to contracts entered into before the 23rd of August 2018, which were still in place, still live contracts in June of this year?
No, because it's the way it works is that they are still live contracts because the termination was invalid retrospectively. And the thing is, the scenario that they're trying to, that will obviously be caught and that will obviously fall within the legislation, and everyone will accept that this is what it's meant to do, is where there's a termination and the purchaser has said, hang on a minute, I don't accept that, and has disputed it and has continued to dispute it from the 23rd of August or whenever on. The new legislation will make it clear that that termination was invalid. But what happens, I suppose, in a circumstance where the vendor terminated and the purchaser said, perhaps in ignorance of their rights, said, I'll have I'll accept the deposit back reluctantly, but I'll accept it. And in the meantime, then the vendor has gone on, maybe sold it to somebody else.
You can't unscramble that settlement.
Well, you can in this sense, in that if the vendor has now put it beyond its power to complete the sale by selling to someone else, you've got Section 10D, which would give the purchaser a right to damages, so that any increase in value that the vendor got would have to be given to the purchaser in damages. But you're absolutely right, Russell. What it does do is revitalise contracts which have been purportedly terminated.
And that is that the intention of retrospectivity?
Absolutely. That's the iniquity of it.
Yeah. Thank you.
It's an unfortunate consequence of it, perhaps, but...
No, I have strong views on retrospective legislation. It's too easy to...
Thanks. One's a comment and one's a question. First one is that 10A is so poorly drafted as to be virtually nonsensical.
Sorry, who's talking? I can't... Oh, yes.
Oh,
right, okay.
Yeah.
Oh, right, Harry, how are you?
I mean, to say that something's automatic, but then requires some action on the, it just doesn't gel.
Oh,
That's-
actually, I do have something to say about that, because there's curious wording in, is it 10, where are we now, 10B, there's some very curious wording. Murray McCutcheon raised this with me. There's the wording that says, 10 capital A, if a sunset clause in a residential off-the-plan contract purports to automatically rescind the contract on the part of the vendor, that's very strange wording. I think that really means that if a sunset clause in a residential off-the-plan contract allows the vendor to rescind,
Yeah, we know what it's supposed to mean,
Things
but it
automatically
doesn't read that way.
but I think that's the point. It's the Sutter and Gondowda point that if it's making that a matter of statutory provision, that if you have an automatic termination, that is taken to be a right to terminate.
yes,
And
which then has
therefore
to be...
it's then regulated by the rest of the section.
Yeah, but that's not how it's drafted. The wording is very poor.
Right.
It should have enabled
enabled
the vendor to terminate, not refer to automatic rescission in the contract.
I think it's got to cover both.
Yeah, but in any event, the question is this, and I don't know whether you alluded to it in your discourse, presumably, having regard to 10B and the rest of it, if the contract is self-determining, so you've got a 5-year sunset clause, and there's a provision that if the plan is not registered or the occupancy permit is not issued by that date, then the contract is at an end, that would not offend the legislation.
What was the provision?
No, if the sunset date provides that in the event that the conditions are not reached, and then goes on to say the contract's at an end if they're not, then that would have been an agreement between the parties ab initio, and that terminates the contract.
Well, not according to 10 capital A, it does.
That's right, that's
It's
precisely.
specific.
If it did say that, I don't know if anyone's ever seen a sunset clause that's drafted quite like that.
No, they're not. But what I'm saying is, if it were, this provision wouldn't have any, because the contract would come to an end by virtue of its terms, not by virtue of a rescission.
Oh, I see your point. Because of the use of the word rescind.
Yeah. I mean, if you contract that the...
This is the old problem. This is the old problem that Parliament is the last one to have caught up. The drafts people in Parliament are the last ones to have caught up with the problem in terminology between rescission and termination. I think it would have to be construed, in order to give the section any effect, it would have to be construed if automatically bring the contract to an end.
Yes, that's right. No, I have little doubt about that.
But on the other hand, it does go on to say on the part of the vendor.
That's right, and this is by agreement.
Well, it's sloppy drafting.
Well, yes, but I think that's a very good point. If you've got a clause, in a
Sanity clause.
under dispute at the moment.
It wouldn't be difficult to draft.
I don't
No, it'd be too late to draft it now.
my view is the Parliament's
All right, yes,
intention.
sorry, we better continue.
If the vendor's application is unsuccessful, how is the new sunset date determined? Who actually says how long the contract's going to stay on foot for?
You mean an application of the court that by the vendor that doesn't succeed?
Yeah. So the contract remains on foot?
Yes.
How long?
Well, the contract
does-
remains on foot with the sunset clause in it. Sunset date is passed.
Yeah.
So that means that the vendor can still terminate, but only when the vendor has got to the point where the vendor can get either the consent of the purchaser or the sanction of the court.
What if the purchaser doesn't consent and the sunset date has finished?
Yes.
They go to court, the vendor can't, the the court says a contract is remaining on foot.
Right.
How long would it remain on foot for? Who actually decides that? Does the purchaser then have, at its own option, I'll end it next week, I'll end it next year?
The purchaser certainly has that option because the purchaser's got an unfettered right to terminate once the sunset date has passed.
9AE, yes. So
That's right. But nonetheless, I can see the force of the question because you're saying, well, the vendor then has to go on with the contract, and that's true. But there will come a point if the development hasn't reached its conclusion, there'll come a point where the vendor will have done everything within its reasonable power to get the plan registered and the occupancy permit issued. Then the vendor just has to go through the procedure again.
But are they at the mercy of the purchaser between that
They're
time?
at the mercy of the purchaser when it comes to consent, and they're at the mercy of the court when it comes to the court's sanction. But what they don't have is an unfettered, unlimited discretion on their own anymore.
there'd be a point in time where the court, you could maybe need a later application to the court where the court would say the material before the court indicates it's never going to be registered. The court's most likely, I would have thought, to allow the vendor to terminate.
It's not res judicata once and for all that the vendor can't terminate. It's only res judicata that as things stand, the vendor can't terminate. So the
So
vendor
you have
could
to
go
vary
back
the
again.
contract then to have a new sunset date if the sunset date has passed? Because how are you going to enforce something
well-
that's already expired?
But that's a problem that exists at the moment. Say you take a vendor who hasn't used reasonable endeavours to get the plan registered, the sunset date arrives and the vendor says, aha, I'm going to take advantage of the sunset clause. Theoretically, purchaser can say even now, no, you can't, because you're in breach of that obligation. Therefore, your termination is invalid. And the purchaser could go to the court, and the court could say, we agree, and so the termination was invalid. So that presents exactly the same problem theoretically. But what it means is the vendor has to go back and try harder, try again.
Well, the Etna and Arif stands for the proposition that the vendor must continue to use best endeavours.
Yes, indeed.
Or whatever the obligation is. Getting close to drinks.
It's not right to get policy and enforcement. You can't enforce it then, or the developer keep going with how we are.
Well, they
You
can.
just
of
sit
course.
back and wait for the developer to do whatever. He can't be forced.
Well,
Not to make a 10E application, no, that's true.
no, the purchaser doesn't have the statutory rights, but the purchaser has a right, if the vendor is in breach of the contract, to claim damages for breach or to get orders from the court. Actually, they are really specific performance orders, but they're specific performance of the obligation to use reasonable endeavours, not specific performance to transfer the property, because the property hasn't been built yet.
How likely is that?
Well, the thing is, who's likely to expend the money to do it? That's true. I agree with you in practical terms.
But one more, I think. Time for one more, because people will be getting hungry and thirsty.
My question is in relation to, normally in a off-the-plan contract, there's the overall right of a vendor to terminate if the economic, etc., etc. So there's the usual paramount right of the vendor. Is this in any way affected? Because this is talking about the sunset clause, but the other one is just the general economic circumstances change, etc., etc.
And we dealt with that earlier on. It's not, those sort of clauses
Can you
are
repeat the
regulated.
question, please?
Yes, and could you also use the microphone a little closer so that...
Turn it on.
Maybe turn it on, yes.
Helps if it's on.
That's right.
Oh, sorry, it's on.
That's much better.
I'm blind. My question was in relation to this is about the sunset clause and the rights to terminate or not to terminate and the procedure you have to go through. But in addition to the sunset clause, in all of the off-the-plan contracts that we've drafted or that I've seen from other solicitors that act for vendors, there's also the right of the vendor, developer, to terminate under certain circumstances, and the circumstances are usually set out, such as, say, because of a change in economics or legislation makes it not viable, etc. Is are those rights, would those rights still stand?
Yes.
The answer is yes. We dealt with that earlier on. The definition of sunset clause that's regulated by these new provisions is very specific. It only applies to a right to terminate if the plan is not registered by a particular date or a certificate of occupancy is not issued by a particular date.
And that's
Any other contingencies, the normal principles relating to the exercise of rights under contingent conditions apply.
Might be one more, I think, just one lucky last.
Yes.
Well, then the next point is, what's the point of this whole legislation scheme if you can just do it under another provision?
Well, can you? That's the thing.
Well, all the off-the-plan contracts that I've seen or have sunset clauses in them, so there is some method in the madness, some reason to regulate.
The other clauses have to be something that's there is a little bit more to it than that. The way we've said it. If the contingency that you build in is just to an attempt to get around the legislation, so that perhaps say instead of saying you can terminate because if the plan of subdivision is not registered by a particular date, maybe you just pick an earlier step in the process of registration or procuring registration, say obtaining a statement of compliance from the council. I think the court could readily, and using consumer protection principles of construction, could readily say that that is in substance saying that the plan is not registered, because that's a necessary step along the way. But if you're talking about not being able to obtain finance, or something happens that the council imposes onerous conditions, unreasonable conditions, those kinds of things, they will not be caught by this legislation, and it's a much, much bigger and deeper policy argument for our lawmakers as to whether they should be regulated.
Yeah, I endorse those sentiments.
I think, in particular, I feel Mr. Lloyd is thirsty.
Yes, I think we all are.
Or hungry.
We've gone over time, but they're very kind of you all to keep to remain. Thanks, Rusty.